the ambassador mentioned I had taken time out of my busy teaching and research schedule, I think you should be aware that for my students back in Montreal, my visit here provided a little gift, a little free time for them at a moment when the term has been dragging on and it has been cold and snowy for a long time. So it's a gift for me to be here, and it's a gift for them that I'm here as well. It's been explained to me that the audience here is mixed this morning. So there are professors of law, there are lawyers, there are students, there are participants in NGOs and civil society. So there's probably a range of background knowledge, a range of interests and expectations. So it's a tall order, in a sense, that I've been given. I wanted to tell you from the outset that I'm going to speak in the first segment this morning about the legal and political steps that led to equal marriage in Canada. And then there's going to be a period of questions and answers and a little break, and then I'll speak to you some more. And then this afternoon there's a further session. So I'm going to be very open to the kinds of questions and concerns that you have, so that by the end of the day we have a sense that we've made a good use of the time. So I'm very interested in the Q&A or in the breaks, getting a sense of how it would be helpful for you, what you would like to discuss, such that the Canadian experience can best inform your work from here, your reflections, and as was mentioned, the further process as your draft bill gets introduced to a new parliament in due course. So we begin, though, looking at the process that took place across many years that led to what in Canada we could speak of as equal marriage. And to be clear, calling it same-sex marriage, or popular media often speak of gay marriage, but in the Canadian context, we're talking about a legal change that allowed same-sex couples to enter the existing model of marriage as it stood. So there's no separate institution known as same-sex marriage. What I'm speaking of in the Canadian context is how it became possible for two men or two women to get married like any other couple and to subject themselves to the same legal obligations and rights and social recognition. So I wanted to begin with saying that. I also wanted to add a little caution. The slide behind us, or in front of you, refers to the path to same-sex marriage. And whenever something has been achieved, it's very easy to look back and you can say, oh yes, there was the path. And of course, we ended up here. But at the time, of course, it didn't feel like a path, or it certainly didn't feel like a path that was going to go in one direction only. And the outcome was uncertain. And there were a number of choices and things that happened along the way. And so I don't want to give the impression that it was straightforward and that people participating in the movement understood that it was simply a matter of time before their goals were achieved. There was a sense of chaos now and then, a sense of uncertainty, a sense at times of thinking that things were moving too fast and that nobody was quite in control. And so I wanted to throw that caution out there because it's the professor's tendency looking back to make things seem very tidy. And so one tends to simplify the story for the purposes of presentation. So you've been warned. It was messier than it's going to sound this morning. Okay, and now it has been suggested to me that a little bit of an overview of the Canadian legal and political structure, not too long, but that a little overview might help position the conversation to follow so that you're best able to participate. And so in Canada, Canada's a federation. The legislative power to make laws of one subject or another is distributed by a written constitution between two orders of government. The Parliament of Canada has power to make laws in relation to marriage and to divorce. The Parliament of Canada, from which the ambassador represents, has power to make laws in relation to criminal law. But the 10 provinces, each with their own capital and their own legislature and their own government, the 10 provinces are the units that have primary responsibility in matters of family law, the relations between parents and children. what spouses owe one another. And so the Canadian story that I'm going to share in the next minutes involves moving back and forth. It involves developments at the federal level and developments at the provincial level and some of the responses that took place between them. So that's a crucial thing to bear in mind. Also, the federal government has more money than the smaller units, and so the federal government is actively involved in social policy. There are a number of federal programs, pensions, training, compensation, elaborate income taxation systems, and so the way the federal government defines spouses or couples for its purposes has a very direct economic impact across the country, and that's important for us to bear in mind as well. Something that came up in the initial conversations I had a couple of days ago, it was suggested that I underscore to you that the law in Canada is a combination. Some of it is enacted or written or legislated law, laws passed by a parliament or by a province's legislature, but some of the laws are also unwritten rules derived from the judgments of courts in keeping with the English common law tradition. So until very recently, marriage in Canada, and which for a long time was restricted to one man and one woman, that definition, that legal rule was actually found in a British case from 1866. And so everybody knew that if you looked in this British case report by an English judge, you would find a sentence saying that marriage, as understood in Christendom, is the voluntary union for life of one man and one woman to the exclusion of all others. That's the historical definition of marriage. And perhaps one final background piece on the sources of law and the regulation of marriage is that for the past several decades, the rights and obligations that follow marriage in Canada have not differentiated between husbands and wives. So marriage, even although it was restricted until not so long ago to one man and one woman, did not impose specific duties on the husband or specific obligations on the wife, as it had in the past. But the struggle for recognition of same-sex couples began on a terrain in which the content of marriage itself was already gender neutral. Spouses owed one another support. Spouses shared property if the relationship ended, but there wasn't a differentiated sense that the wife owed obedience and the man owed protection, as there had been in the not-so-distant past. So the starting point was a gender-neutral legal structure for marriage, although restricted to a man and a woman for some time. The next, and I think final big piece of background to introduce to you is that both orders of government in Canada, both the central government in Ottawa and the provincial governments, are subject to a rights instrument. I think the ambassador mentioned it, the Canadian Charter of Rights and Freedoms. And the Charter includes a guarantee of equality and a guarantee of freedom from discrimination. And as was pointed out to me since I arrived this week, relatively similar in its wording and flavor to Section 30 of your Constitution. So there's a guarantee that every individual is equal before and under the law and has the right to equal protection and equal benefit without discrimination. And this list, and if you look at the text that's been translated for you, a couple of things come to your mind in this context. One is that we see the word sex included. There's protection against discrimination on the basis of sex, but we see no mention of sexual orientation in the written Charter of Rights. And perhaps the second thing that the careful legal readers would see, my students don't always notice this, but the list of grounds on which protection is granted is not a closed list. It's an inclusive or a non-exhaustive list. The words in particular in English indicate that the drafters of the rights instrument were giving us examples of the bases of protection from discrimination, but the door was not shut to other things. And we're going to keep in mind that open character of the equality guarantee, because it will turn out to be very important in the story that I'm sharing with you in the minutes to come. And the last background piece is that claims brought under the Charter of Rights and Freedoms can be brought, I simplify a little bit, but basically brought in any court. And there is no distinct system of constitutional courts. So one brings a rights claim in the court relevant to the legal issue concerning you, and eventually all legal disputes may find themselves before the Supreme Court of Canada. So the story I'm going to share with you this morning focuses on decisions by the Supreme Court of Canada, but some of the rules in issue are rules from provinces, some of the rules in issue are rules from the Central Parliament in Ottawa, but they all make their way up sooner or later to the Supreme Court of Canada. That's the background on the sort of political and legal structure in Canada. And having had the opportunity to read in translation your draft bill for civil union or civil partnership, I thought it might be helpful quite early in our discussion today to draw out what struck me as some of the choices. If you were starting with the social and political problem of saying, we have no way of recognizing same-sex couples, we know same-sex couples exist in our society, we believe they're entitled to recognition, what are some of the options that would come to your mind if you began as a drafter, as a lobbyist, turning your mind to this problem? And the Canadian experience is interesting, and I hope instructive a little bit, because in several interesting ways, the choices made in Canada as the Canadian experience unfolded show themselves to be quite different from some of what's being proposed here. And so I hope at a minimum that our time together today allows you to be better informed as you look at your own choices and lobbying efforts here in Thailand. So there are a number of things you would say to yourself or ask yourself if you were trying to say, how do we solve this problem of the utter lack of any legal form for same-sex couples? And so one of the questions you would ask would be whether you were opening up some kind of voluntary mechanism. Are you opening up a relationship option that two consenting adults can choose to access when they both consent in an informed fashion? Or might you choose to attach legal effects to couples simply because they live together in a way that they might not choose? And as I will report in the next few minutes, in Canada there's been a combination of those. So for some purposes, same-sex couples are treated as spouses simply in virtue of their living together. And there's also the possibility of making the formal decision to say, you and I are going to seek recognition as a married couple, we're going to go through a formal process. But there's a clear design choice whether you would wait for people to seek recognition or whether you would attach recognition to them. That's one question, the kind of consent or attachment design choice. A second choice that would confront you as a policymaker or drafter or lobbyist would be, if you were going to recognize same-sex couples, would you intend simply to expand the boundaries of the existing marriage? Would you simply alter its conditions of entry? Or would you say, we'll leave marriage as it is and we'll create something separate on the side? And that's the current proposal in Thailand. But the Canadian approach was to alter the entry requirements or the access such that a same-sex couple enters into marriage as it existed before, the identical rights and obligations, the identical interpretations, and so on. I should also note that during the years in which the movement was on its way but had not yet changed and achieved access to marriage, several Canadian provinces did create a new institution, a registered partnership. The province of Quebec created something called a civil union. But what I think is very interesting in this context is each of those new things created beside marriage was open to different sex couples as well as same-sex couples. So even when new institutions were created in the Canadian experience, and I report this factually rather than making a judgment about it, but nowhere in Canada was there ever a legal model created which was restricted or destined only for same-sex couples. So there has always been a sense that each legal model should be open, that there should not be different institutions for people based on their sexual orientation. That's not, of course, the choice made in other states. The United Kingdom created a civil partnership for same-sex couples only, but I can report that in Canada there was considerable reluctance to pursue that kind of path of two separate avenues. So I've touched on that question of whether a side or new construction would be open to all couples or only same-sex couples. Another question you might ask yourself is whether same-sex partners, once recognized, would have the same rights and obligations that married couples have traditionally had, or would they have something different? And people who compare recognition forms around the world would know in France, for example, there is a recognition called the PACS, but its content is not identical to marriage. In the Canadian context, same-sex partners are recognized with identical legal rights and obligations. And the final set of design choices, and these are perhaps a little more technical for the real legal drafters in the room, but how detailed would the legislation be when it extends to same-sex couples? Would there be a general statement simply that same-sex couples are included? Would you state, this is very legalistic, would you state that same-sex couples will be included mutatis mutandis, or included, but with some suggestion that there may be some differences that we will need to work out as we go along? Or would you try in advance as a legislative drafter to anticipate every possible legal issue that recognizing same-sex couples might arise and try to provide some kind of answer for it in writing from the outset? Three different approaches, and the quick answer is that the Canadian approach was to be fairly general in its legislation, but as I will report later on, there have been some legal issues that have arisen that it turned out weren't addressed at the initial moments and caused problems later. Okay, so that in the Canadian context I'll report later, but judicial interpretation and some legislative amendments have been required to deal with problems that have arisen after opening up marriage. So that's the kind of design choice stuff I wanted to share with you, that there are a number of decisions made and that there's nothing inevitable about the way towards extending recognition to same-sex couples. And so we turn now to what we could call the social and legal path to same-sex marriage. And I need to emphasize that it was a process that took place over a number of years. It was a process that took place at the national level and in the provinces. And the process took place in different institutions of government. So some of the developments took place in the courts through cases brought under the Canadian Charter of Rights and Freedoms, brought through the guarantee of equality that a few moments ago I suggested was similar to Section 30 of your Constitution. And some of the work was done through legislatures and lobbying and organizing through legislatures enacting new laws. So it took place in many different forums over a number of different years. And so I do want to emphasize that there wasn't a single moment where everything was changed at once. And so that, I think, is important to remember, perhaps, if you find yourself with a legal proposal that would satisfy some interests, but that other people may feel isn't perfect or complete. The Canadian experience, at least, was incremental. So I would suggest, and people could tell the story differently, but legislative changes around homosexuality in the Canadian context began at the end of the 1960s. The criminal laws around same-sex conduct were largely removed, not completely, but certainly liberalized substantially. In the 1970s, 1980s, and 1990s, sexual orientation was included as a protected ground, as a basis for protection in laws against discrimination. So it became a basis for challenging your dismissal from employment, for challenging a landlord's refusal to rent an apartment to you, or a merchant's refusal to sell you goods and services. Sexual orientation was recognized with the idea being that it was inappropriate to discriminate on individuals on the basis of their sexual orientation. But throughout this period, 1960s, 1970s, 1980s, there is yet no recognition of a couple, that two men or two women might form a legally recognized family unit. So that was going to come later. So those are the legislative changes around homosexuality. I understand there isn't any criminal prohibition to deal with here, but if one is looking at a context, certainly one would expect that criminal penalties would be removed a long time before a society was able to contemplate positive recognition of gay and lesbian families. The next stage then would be legislative changes around marriage and couples. And here the story, in a sense, steps a little bit away from gay and lesbian couples, just to the general observation that Canadian marriage and family law differentiated itself in some ways from very traditional focuses on marriage, such as we still see in much of the United States. And so in the 1970s, and even before that to some extent, Canadian legal and social policy began to recognize, to continue to recognize married spouses as a key part of laws and as a key part of social programs and taxation and social assistance and pensions of various kinds. But it began to recognize unmarried cohabitants, a man and a woman living together. It began to recognize that kind of couple as family-like too, or as marriage-like. So social policy began to loosen, if you like, its grip on the idea that the traditional married couple was the only unit known to Canadian law and policy. And this loosening, this recognition of people living together as giving a basis for family life, that's part of the story that will come back in a couple of moments. Now we turn to the activity in the courts. Cases or challenges brought under the equality guarantee in the Canadian Charter. And a number of these initial challenges, very important, we can see looking backwards today, in laying the groundwork for the eventual demands for marriage. These early challenges did not bear on marriage itself. They were concerned with other things. And I'll signal at the outset that some of these cases were brought on behalf of happy couples wanting to be recognized together, and a couple of them were brought in a context where a same-sex couple had split up, and one person was seeking to enforce against the other the rights and obligations that would have attached had they been a married heterosexual couple. So there, perhaps in a predictable fashion, the recognition has sometimes been driven by people wanting to be seen as a couple, and has sometimes been driven by someone wanting to be seen as a legitimate divorcing spouse. So some of the cases are, it's easier to cheer when the happy couple is recognized, and it's a little more ambivalent sometimes when the couple splitting up is suddenly recognized as having rights and obligations that they did not have when they began living together. So several steps, and this story moves through the 1990s. In the early 1990s, a claim was brought that the Canadian Charter required the capacity for same-sex couples to marry. This was in 1993, and the case was dismissed, and the majority of the judges thought it was pretty obvious that that was crazy, that the Charter might guarantee individual rights, but that the Charter was not intended to transform the traditional institution of marriage. And there was a single judge who dissented, but back in 1993, it seemed pretty unlikely in people's minds that I would one day be here today speaking about the Canadian experience in this regard. A couple of years later, a couple of two relatively elderly men who had been together for decades brought a challenge. They were living together, and they objected that they were denied the benefits of a federal income assistance scheme or a federal pension program, and if they had been a different sex or opposite sex couple living together, conducting their lives exactly as they did, they would have been recognized as cohabiting spouses. And so they said, this is unfair, we're excluded, and the only basis of our exclusion is sexual orientation. And they lost the challenge, but in the way that sometimes legal victories or legal decisions have multiple effects, their actual claim was denied. They were sent away without any money under the federal scheme, but they did persuade a majority of judges of the court that the equality guarantee, which we saw on the screen a few moments ago, the equality guarantee similar to Section 30, and we talked a few moments ago about how that equality guarantee had a non-exhaustive or open list of protective grounds. This elderly couple and their lawyer persuaded the judges that sexual orientation was similar enough to the other things already written into the text of that guarantee, that sexual orientation was also protected under the Canadian Charter. And so in the particular case they lost, but from 1995 onwards, we look at that written text, we look at that written equality guarantee, and we understand that sexual orientation is included along with the things that are written down. And so that was a crucial moment in the path. Another development came 3 years later. I mentioned that through the 1970s and 80s and 90s, the provinces of Canada added sexual orientation to the statutes which provide protection from individual discrimination, what are called Provincial Human Rights Acts. What I didn't say a few moments ago was that one of the provinces made a very deliberate decision not to add sexual orientation. It decided it did not want to protect gays and lesbians from discrimination on the basis of sexual orientation. And the government's decision not to do that, its non-action, its refusing to recognize sexual orientation, was itself challenged under the equality guarantee in the Charter. And the Supreme Court of Canada concluded that the government itself was discriminating on the basis of sexual orientation by failing to protect its gay and lesbian citizens in the way it protected everyone else. And so the Supreme Court showed its willingness to accept a claim under the Canadian Charter on the basis of sexual orientation. And there was some backlash following this decision. So the ambassador mentioned that the path hadn't been sort of rosy all along the way. There was considerable resistance in some quarters of the province affected. But the Supreme Court of Canada had shown itself open to recognizing the dignity and rights of gays and lesbians in the country. Just a year later, we have one of those cases I had mentioned where it's not a happy couple, but rather separating partners. And so in 1999, a lesbian couple who had lived together for a number of years had split up, and one of them had been running a business and the other had been running the home. And the one who was in the home and had much less money attempted to claim money from her former partner and said if we were living together and we were of different sexes, Ontario's family law would recognize us as a couple. The fact that it doesn't recognize us is discrimination. And this claim was successful this time. So the Supreme Court of Canada accepted that once a government recognizes unmarried cohabitants, people simply who live together, it cannot draw a line between the unmarried cohabitants who are of different sexes and the unmarried cohabitants who are of the same sex. And the Supreme Court of Canada, it was interesting, it used language of dignity. It said that the legislature's refusal to recognize same-sex cohabiting partners, that legislative decision sent the message that same-sex couples were less committed, were less valued, were less able to have enduring relationships with economic interdependence. And at the same time, the Supreme Court said, of course, this has no implication for marriage. So we're recognizing that there can be an equality claim on the basis of sexual orientation. We recognize that men and women can form couples and families, but this has nothing to do with marriage. And some people at the time doubted whether that could be true. But it means that as late as 1999, the Supreme Court attempted to be very plain that it wasn't tampering with the institution of marriage as it was known. After that,